Welcome back to another segment of What the Heck is Going On? I am your host, Jeff LaFrance. Today I have the extreme pleasure to introduce a man that has for years been fighting the tyranny that threatens our great country. I have watched this man and his wonderful wife Judy endlessly over the years, filing lawsuits, holding demonstrations, and fighting battles against all enemies, foreign and domestic. Today, we are facing some of the most challenging times in modern history. Leadership in America has deserted its responsibility and is leading us down a slippery slope that threatens the future of our republic. Our elected officials no longer serve the citizens, but their own special interests. Our backs are against the wall. All remedies have been exhausted. We now need to take bold and decisive action. Now, I will take you to Shasta, California, to hear what this extraordinary and devoted man has to say. It is my extreme pleasure to introduce you to Bob Schulz.
And we're so grateful to have you with us today.
Thank you all very, very much, Jan. Thank you. And it is just a delight to be here at Mount Shasta. Just takes your breath away. So I pledge allegiance to the Constitution of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. Okay, if I'm an indicator, most people don't begin to wake up about these issues until they're about 40, unless maybe someone like Ron Paul comes along and gives a message that resonates, a message of freedom that resonates with a lot of younger people. So 1979, something was happening in my neighborhood. The government there was prescribing, we realized had manufactured a crisis, and had let the people know in the community that this beautiful queen of New York lakes, Lake George, was going to, in their words, turn pea soup green in 6 to 10 years. And it was all because our on-site septic systems were contaminating the lake. And so they were advocating a huge, huge project, run sewer lines down both sides of the lake, bring them together at the bottom of the lake, and then run that wastewater out of the Lake George watershed over the ridge to the Hudson River watershed, where they would then treat it. There was a notice in the paper that my wife brought to my attention. It was a meeting scheduled at the little firehouse around the bend from where I live. And this was the new sewer commissioner, the county sewer commissioner, was going to be talking about this project. And Judy said, why don't we go and listen to what he has to say? So we went, and after his presentation, I raised my hand to ask him, a government official, a question or two. And had I not gone to that meeting and raised my hand, I wouldn't be here today. He said, no questions, see me later. And I felt that the question and his answer should be heard by all the people in that room. The room was packed, and this was a huge project. So we went home, and I decided to look into this issue. And what I learned was that our government was manufacturing this crisis and had prescribed this solution that was going to benefit a few of them, but at everybody else's expense, and they were going to violate the law in the process. To make a long story short, to get answers to those questions, we obtained an attorney, had never had an attorney before, and did something I'd never dreamed of doing before, and that is brought the town and county to court. In 1982, the highest court in the state, in a very robust decision, gave us all the relief we were requesting. They undid the results of a countywide referendum, and nullified all the resolutions passed by the town and county board in approving and financing this project. And in the end, a full-blown environmental review of this project was undertaken, and the conclusion was the last thing you want to do around Lake George would be to add any more sewers. But that changed my entire concept of government. Until then, I had been led to believe that government is always benevolent and that it always has the public interest uppermost in its minds, and that you can trust these people. That opened my eyes, and a few years later, I decided to do this kind of work. I felt it was my personal responsibility, felt I had been duped, and I felt it was my responsibility to begin paying more attention to what government is saying and doing, and comparing its behavior with the requirements of our Constitution, both state and federal, and its laws. And it was also a responsibility to encourage other people to do the same thing. But the point is, now I've learned two lessons about government, unfortunately. One, that it's not above manufacturing a crisis and prescribing a solution that's going to benefit a few of them in office and their friends, but at everybody else's expense. But I also learned that government can be vindictive, that they can hurt you simply because they don't like you. If something smelled, it was usually rotten, and how important it was to confront government intelligently, rationally, and professionally, confront government when they are doing something that they are not authorized to do, or not doing something that they are mandated to do. We were twice successful prevailing against a very popular governor in New York for violating the state constitution and using public money to sway the results of elections, a pretty serious charge. And then in 1997, we decided to collapse the statewide group and form the We the People organization. The We the People organization has two separate entities. One focuses on, it's a research and educational organization, and the other is a civic action organization. So the We the People organization I believe strongly in civic education, but education without action is for naught, just as action without education is for naught, and also to hold government accountable at every level. Picture this, if you will, as part of the vision we have for the We the People Congress. You know, as you go through your state capitals, you see this building. Every state capital has them. The architecture may vary from state to state, but there's the building, and it has a dome on the top. And people instinctively now know that that's where the government is doing it for or to the people. We know that. We need another building in every state with distinctive architecture. And my choice, personal choice, is Monticello, Jefferson's home in near Charlottesville, Virginia. We need a building like that in every one of the 50 states. And in the end, people will come to instinctively know when they see that building that that's where the people are watching the government. And within those buildings, you would have attorneys and paralegals and supporting the organization set up within the state. We think we're at a point where we need to take a page out of the founders' playbook. We find ourselves in much the same situation as the founders found themselves in, and we have petitioned for redress of these grievances. Many people have done this. We can only talk about our record, what we, the People organization, with people around the country, have been doing since our incorporation. We petitioned for redress of these grievances, and our repeated petitions have been answered only with repeated injury, or worse. We need to bring some of our number from each of the 50 states to convene at a Continental Congress people with a passion for the Constitution, people who understand the way the system is designed to work, and the fact that the way it's working is in sharp contrast to the way it's designed to work. People of good character, people who are respected in their communities, to go off and meet and talk about these grievances and settle on some course of action that the free people of this country can undertake to bring the government back under the control of the Constitution and therefore the people. So we're repeating history. We need to repeat that history. There will be a Continental Congress this year. We're not sure where it will be. We have inspected facilities and received proposals in Philadelphia, at Colonial Williamsburg, in Boston, and at Jekyll Island. Interesting.
Very good.
Interesting. I would imagine there are some people here who don't understand the laughter. Would you raise your hand? There are some people who don't understand the laughter, so let me explain. In 1913, there were some very prominent, highly recognizable, powerful people who got on a train in New Jersey, and they took the train down to Jessup, Georgia, and then rode over to Jekyll Island. Jekyll Island at that time was the retreat for the elite. So you had buildings there owned by the likes of Rockefeller and J.P. Morgan and so on. And there was a large, very large lodge there. And there was duck hunting and that sort of thing. But the people who were on the train, this group that we're talking about, they traveled surreptitiously. They disguised themselves for the trip down there. And one even brought a shotgun case in case he was recognized and asked, what are you doing? So he could explain he was just going down there to do some duck hunting. But what did they do when they arrived down there? They wrote the Federal Reserve Act. And it was then passed during the Christmas break when there were not a lot of congressmen present. In 1913, we not only got the Federal Reserve Act, but we also received the 16th Amendment, the so-called Income Tax Amendment. It's no accident, in my humble opinion, that we received the Federal Reserve Act and the 16th Amendment at the same time. I believe the imposition of a direct unapportioned tax on labor, which by the way violates the taxing clauses of the Constitution, but setting that aside for the moment, a direct or a tax on labor in public finance terms is the best form of lender security. It's called lender security. So it was no accident that we received both the Federal Reserve and the income tax in the same year. And I was at a meeting like this in Savannah, Georgia, about 3 weeks or 4 weeks ago, one Monday night. And I was due in Jacksonville, Florida, the following Tuesday night, the next night. So there I was on the road from Savannah to Jacksonville. And there was this large sign, and it said Jekyll Island this way. So I decided, I've often been curious, I wondered if I could go over there, what I might find, and gee, could I even stand in the room where they wrote the Federal Reserve Act? So I drove over and was delighted. The place is extraordinarily preserved and a fully functioning lodge It's open to the public. It's now owned by the state of Georgia. It's a state park. And I went to the room. The room is now known as the Federal Reserve Room. It has 2 doors entering into this conference room, and they have plaques on the door, and the plaques say Federal Reserve. And next door, there's a plaque on the entrance, the door into that room, and it says J.P. Morgan. That's the J.P. Morgan room. So I found out that they actually have room for conventions there. So I inspected the facilities, and I wondered if we might hold our Continental Congress here. Wouldn't that be ironic? You know? The beginning and the end. But I got to thinking, all the leaders of these different groups might be willing to get on a train in New Jersey sometime in May and take the train down to Jessup, Georgia, and get on the bus and go over to Jekyll Island for a couple of days, just to help lay the groundwork for the Continental Congress, the upcoming Continental Congress. So I called G. Edward Griffin, who I know quite well. G. Edward Griffin is the author of a book called The Creature from Jekyll Island. And of course, the creature is the Federal Reserve. Mention Jekyll Island, and any one of these meetings are from Hawaii to Maine, and we get chuckles and laughs. Most people in the freedom movement are quite familiar with the story. So I called Ed, and we talked about this. And first he said the idea of the Continental Congress is outstanding. He said it is the appropriate next step. It is where we as a free people need to go. And he also said that the idea of the train ride in May, in advance of the Continental Congress, is an excellent idea, and I'll be on the train. He said, I'll be happy to get on the train. I then called Edwin Vieira, and those of you here, I'm sure some of you know who Edwin Vieira is. Edwin Vieira has 4 degrees from Harvard. Edwin Vieira argued and won 3 cases at the United States Supreme Court. He knew that the judiciary in this country is highly politicized, and the legal community, they're highly politicized and quite corrupt. But he also knew that monetary policies bring countries down. And he knew that there was something wrong with the Federal Reserve Act and the way with our monetary policy. He published a tome. It's called Pieces of 8. You can Google Pieces of 8 and find Edwin Vieira's work. By the way, he is the brother of Meredith Vieira, who's on the Today Show every morning. And all of those siblings are highly accomplished people. But Edwin Vieira, in my opinion, is probably, I think he's the foremost expert on the constitutionality of the Federal Reserve. But when he finished that work, he knew that we were in for some very tough sledding. He knew that we would be experiencing what we're now experiencing. He knew this when he finished that work in 2003, 2004. That eventually there would be some real turmoil, and that the government would then be putting paramilitary forces on our streets and that sort of thing. And so he became quite alarmed at that, believing that the absence of well-regulated state militias is unconstitutional. The Second Amendment says well-regulated state militias are essential to the security of a free state as the only constitutional form of constitutional homeland security. So Edwin Vieira, a foremost expert on the Federal Reserve, said he'll be on the train. He'll take the train ride down to Jekyll Island on the 3rd week of May. I then called other leaders of the freedom, liberty-oriented groups, and everyone I've spoken to has agreed that they will take the train ride. So there will be a train ride sometime in May. We have a government that is routinely now violating the Constitution. I was asked at a meeting like this not long ago, a week or so, 10 days ago, is there any provision of the Constitution that the federal government is not now violating? And I was hard-pressed to think of one. Maybe the post office, or something of that sort. So we have a government that the evidence strongly supports the charge that the government is violating the tax clauses, it's violating the money clauses, it's violating the war powers clauses, it's violating the privacy clauses. There is absolutely no authority for the government to develop a North American Union that would effectively obliterate the northern and southern boundaries of our country. I don't mind if Mexico becomes the 51st state and Canada the 52nd, and they apply for statehood, and they have state constitutions that guarantee their people the same rights and so forth that our state constitutions guarantee our people, but that's not what's happening. The illegal immigration issue is a constitutional question, not a political question. Under Article 2 of the Constitution, it plainly says that the president shall, quote, faithfully execute the laws. And we've had laws on our books for decades dealing with illegal immigrants that aren't being enforced for whatever reason. They're just simply not being enforced. We have a lot of federal gun control laws that are in violation. All the evidence suggests they're in violation of the Constitution. We all have a right to vote, but we also have a right to know, a fundamental constitutional right to know, with the emphasis on the word know, that our votes are being accurately counted. You cannot know that your votes are being accurately counted if they're counted in secret, right? That's what happens when machines count votes. When computers count votes, they're counted in secret. We need paper ballots hand-marked and hand-counted. It's not difficult. Canada does it all the time. The Natural-Born Citizen Clause, we've come to learn, exists in the Constitution. The president, in order to become president, one must satisfy the eligibility requirement of the Natural-Born Citizen Clause. Wow, that's interesting. There's a high level of interest in that here. In that case, we'll talk about it for a minute or two. About a year ago, I heard these rumors, but I thought, well, Mr. Obama may not be eligible for the office. And I just discounted them. I said, that can't be. I mean, that's sour grapes, whatever it is. The man's a citizen. I mean, he's a senator. And he couldn't possibly have gotten this far. And so I just put it out of my mind. But then I read Judge Surick's decision, speaking about judicial corruption. Judge Surick is a federal judge in Pennsylvania. There was a citizen of Pennsylvania, Phil Berg, who undertook research, and he put together facts in support of his argument that Mr. Obama is not a natural-born citizen and therefore not eligible to be president, and he wanted him stricken from the ballot before Election Day. Mr. Berg, none of us are, I mean, we're all entitled to our legal arguments, but we're not entitled to our version of the facts. None of us are. Whether you're in a civil action or a criminal case or whether you're dealing with the government, you're entitled to your legal arguments. You're not entitled to your version of the facts. So Mr. Berg filed his version of the facts. It was up to Mr. Obama and the DNC, the defendants in the case, to refute those facts and to offer their own evidence. Under the federal rules of civil procedure, Mr. Obama could have, but didn't. he could have submitted some evidence showing his eligibility and asked the court to dismiss the case because Mr. Berg had no case. But that's not what he did. He asked the court to dismiss the case because Mr. Berg lacked standing to be in court. And if he lacked standing, then the court had no jurisdiction. And that's what the federal judge did. Now here's Mr. Berg. He's 56 years old. He has to live under the Constitution for the rest of his life. There are going to be future elections and future presidents. The natural born citizen clause isn't going anywhere. The court has never declared what it means, natural born citizen. It's never had, this question has never come up before. So the court has never had to step in and declare its meaning. So Mr. Berg has raised a constitutional question. Whether or not Mr. Obama is going to fill that office is clearly a decision that's going to have some impact on Mr. Berg. To dismiss the case because Mr. Berg has no standing, and to go on and further and say that his harm is no different from the harm, which the court said, is no different from the harm that everybody else in the country is going to experience. His injury is no different than everybody else's injury. In other words, if you don't like it, take it up with Congress. It's a political question. Nonsense. It's a constitutional question. It is not a political question. So I knew immediately when I read Judge Surek's decision, there's something here. There's something wrong here. And I started paying a bit more attention to this issue. For instance, I noticed that there was another case filed in Hawaii by a fellow named Andy Martin. Andy Martin asked the court there to direct the Hawaiian officials to provide access to his vault, Mr. Obama's vault copy of his original birth certificate. So he asked the court to direct the Hawaiian officials to provide access. We all have one original of our birth certificate. It's in a vault in the state where you were born. It has it has 3 signatures: the attending physician, the local registrar, and one of the 2 parents must sign the birth certificate. And the birth certificate lists ages of the parents, the hospital where the birth took place, and the birthplace of each parent. That's all that information is on the original vault copy of the birth certificate. And this fellow just asked the court to direct the officials to provide access to that, so we can see if the man about to assume the office is eligible to assume that office. The court dismissed the case, saying that it would be an invasion of Mr. Obama's privacy. I noticed another case. A brilliant attorney in New Jersey. His name was Leo Donofrio. I always enjoy reading legal briefs dealing with provisions of the Constitution where the court has never, they're called first impression cases, where the courts have never declared what they mean. The natural born citizen clause was the focus of Leo Donofrio's lawsuit. So he did the research. He went back in time, looked at all the historical documents to determine the founder's intent. What was the intent of the people who put those words there? What did those words mean when they were added? It's called the historical context and purpose approach. He determined from his research, and he backed it up very plausibly, I read his brief, he determined that in order to be a natural born citizen, the person has to have, both his parents have to be U.S. citizens, and you have to be born on U.S. soil. And the reason for this, back then, to the founders, they wanted to make sure that the person who held that office that there was no possibility that he would have dual loyalties. And so he brought that case, and he asked the court to order the New Jersey Secretary of State to remove 3 names from the ballot before Election Day, because he said none of them satisfy the natural-born citizen, the eligibility requirements of the Constitution. Who were the 3? Mr. Obama, Mr. McCain, and there was a 3rd person on the ballot who was born in Nicaragua and was in this country on the basis of a green card. He wanted all 3 removed. Yes, it's true. Secretaries of State approve the names of the people who are placed on the ballots. They have now, in response to this question that has come up in this past election, they have admitted it's not their responsibility to determine the eligibility of the people who are being placed on the ballot for the position of president. The Federal Election Commission has admitted it's not their responsibility. In this case, the DNC has declared it's not their responsibility. It's our responsibility. It's up to the people, in other words. And here's what these people were doing. Mr. D'Onofrio, Mr. Berg, and this fellow Andy Martin, and Orly Tates, and these lawsuits are continuing. So what did happen to Mr. D'Onofrio's case? It was dismissed, and it got to the Supreme Court of the United States in record time. The way the Supreme Court operates, the 9 justices meet every Friday, and they decide which cases they're going to hear. And by 10 o'clock the next Monday, they announce their decisions. So Mr. D'Onofrio's case was on the agenda for December 5th to be discussed by the justices. They were going to decide whether they were going to hear his case based upon the original intent behind those 10 words. It was that morning I was watching the Today Show when Pete Williams, the NBC correspondent, whose beat is the Department of Justice and the Supreme Court, he was there reporting, and this is NBC's first time that I was aware that they had mentioned that there was a question of eligibility. And Mr. Williams announced that, was reporting, that the D'Onofrio case was on the agenda for the Supreme Court that Friday, December 5th. But he went on and said that the Supreme Court justices were not going to hear this case, in his opinion, because they, the judges, the 9 justices, would not want to overturn the will of the voters, as though this were a democracy, and the voters have spoken. We are a constitutional republic. This is not a menu. We don't get to pick and choose which parts of it we like or are going to enforce, and which parts of it we don't like. And that's essentially what Pete Williams was saying, that this is a democracy, Constitution really doesn't matter, the voters have spoken, that's that. So we have a government that is routinely violating the Constitution, at least all the evidence. We use constitutional scholars when we do this work, the research and writing these legal briefs and these petitions for redress. We do not deal with opinions. We only deal with facts. And so all of the facts argue that the government is violating all of these provisions, and we have petitioned them, and the record clearly shows that, as with the founders, who had been petitioning their government for a redress of their grievances, their petitions were being answered only with repeated injury, the same is happening to us. Our petitions for redress of all of these grievances have been met with repeated injury. The record clearly shows that the government refuses to be held accountable. They absolutely refuse to justify their behavior. There are actually 2 accountability clauses in the Constitution. Let's talk about the First Amendment. What 5 freedoms are guaranteed by the First Amendment In the order that they're mentioned, please. Anybody? 5 freedoms guaranteed by the First Amendment in the order that they're mentioned. Any volunteers?
Freedom of religion.
Freedom of religion, worship is the first, yes. Second? Speech, that's the second. Third? Freedom of the press, yes. Fourth? That's the Second Amendment. What's the fourth freedom guaranteed by the First Amendment?
Right to people be secure.
I'm sorry, what was that?
Right to people be secure in their possessions.
That's the Fourth Amendment.
Okay, sorry.
The fourth freedom guaranteed by the First Amendment. What are we doing here today? We're assembling. We can still, in our country, get together and criticize the government or whatever. It's still a freedom guaranteed by the First Amendment. Yeah, and the fifth freedom guaranteed by the First Amendment, anybody? Redress. The right to petition the government for redress of grievances. Redress means remedy. We have this fundamental right to petition the government for redress of grievances. This is what it means. No court has ever declared what it means. If we have some evidence that the government is violating the Constitution, and we call them on it by petitioning for a redress of the grievance, they are obligated to respond. Can't make them respond, but they are obligated to respond. And if they don't respond, then what have we got? We've got a government that has turned its back on the Constitution, and we respectfully petition them for a remedy or for a redress of this grievance, as the founders had been petitioning their government for a redress of their grievances, and they refuse to respond. Then what? What rights do we, what non-violent course of action is then open to us as a free people?
Don't pay your taxes.
He's exactly right. He is exactly right. The light of liberty was lit here, nowhere else. The cause of America is still the cause of the world. So we, by our terms, we've decided we need a government to secure our rights. That's why we set it up, to secure our rights. No more, no less. We need protection from one another and so on. So we need some form of government to do that. Who does this govern? Who does the Constitution govern? It governs the government. It's a set of principles to govern the government, rules to govern the government, not us. We're hardly mentioned except we adopt it. By its terms, we have enabled the three branches to do the job we want them to do, but we have also heavily prohibited and restricted them and mandated them to do a whole lots of things, to keep them from doing certain things, and to mandate that they do other things. So if they violate this, and then we call them on it, and they ignore us, is that a government that you recognize anymore? It's not the government we set up.
Not a government.
Then why should we support it? If they don't support the document, then why should we support them? That's what the framers had in mind when they put those words, those last 10 words, in the Constitution. They put those words there as a critical part of the overall balance of power between the people and the government. If the government violates any provision of the Constitution, you can call them on it. You can petition them for a redress of these grievances. They are obligated to respond. If they don't, then you can withdraw your support and your resources until your grievances are redressed, until they're ended or reversed. That's the way it's designed to work. There is no other non-violent way to hold the government accountable. However, we also know, whereas that used to be the case, there was a time in our country It's history. Until 1830, if someone had a grievance, especially if the grievance was a violation of the Constitution, they petitioned their congressman for a redress of that grievance. And until 1830, that petition always went to a committee, unless it was totally frivolous or violent or libelous. It always went to a committee. And every Monday, Congress dealt with petitions for redress of grievances. That's the way it worked in this country until 1830. But in 1830, Southern congressmen prevailed in the House, and they got a gag rule. The scholars call it a gag rule. They got a gag rule passed. They said any more of these petitions from these abolitionists who want to end this practice of slavery will be permanently tabled. First time the government ever went on record saying we don't have to listen or respond to the people. And it took John Quincy Adams 8 years to get that rule repealed. But the damage had been done, and now this right has all but been forgotten. Until now. So we have this right to hold them accountable. There is an accountability clause in the First Amendment. And we have been petitioning, claiming and exercising that right to hold the government accountable to our Constitution, and they've been ignoring it, ignoring the petitions, or worse. So what is our responsibility? What's our duty under these circumstances? Do we just go about worrying about our family and our careers and letting George take care of these matters, whoever George is? Do we have an individual duty or responsibility as a free people to confront the government when they step outside the boundaries? Do we have an individual duty and responsibility to hold government within the boundaries and get them back within the boundaries that we have drawn around its power? The answer, I think, is yes. But the problem is, of course, that individuals and small groups cannot prevail these days. Individuals and small groups get nowhere if we're trying to hold the government accountable. It's virtually impossible. There was this fellow Mahatma Gandhi who brought India out from under British rule. And he said, when the people are up against unjust and uncivil government and laws and they're entitled to reform, they'll get it only if they follow a three-part formula. He said, if you're missing any one of the three parts, you'll fail. What were the three parts? He said, the people have to be proactive, in their face a bit. They have to be nonviolent, and they need a mass movement or a critical mass. We need a critical mass. We need a mass movement if we're going to preserve, protect, enhance individual liberties, if we're going to preserve our constitutional republic. We need a critical mass, a mass movement. What we see is the first step is the Continental Congress. Picture a large room, Jekyll Island or somewhere else. In that room, picture 50 tables, one for each state. One state, one vote, but 3 delegates from each state chosen by the people in the states. People with a proven passion for the Constitution as authors, scholars, activists, whatever. Picture another 50 tables in that room, one for each state. Out of respect for the role that the states have been given in our system of governance, they'll be invited to send 3 of their number from each state legislature to come and observe. Not to participate, but to observe. The states today are inextricably intertwined with the government, with the federal government. They've sold their souls many times over for a plate of beans. But they'll be invited to come and observe And there'll be room there for members of the public and the other government and the media to observe, not to participate, but to observe. Now, what will these delegates be doing? Every day, there'll be stenographic services, stenographic record, stenographers, recording everything that is said in that room, and a live webcast, reporting, making a record of everything that is said in that room for people to view around the country and around the world. What will they be watching? What will they be listening to? They'll be listening to these delegates every day with facts, no opinions, going through the history, the meaning, the effect, and the significance of our Constitution and its provisions. And with facts, discussing how our government is violating these constitutional prohibitions, restrictions, and mandates. And with facts, how the government has been, how attempts have been made to petition the government for redress of grievances. And with facts, the government's response, or lack thereof. And then they will be discussing, debating, what course of action should the people of the free people of this country take under these circumstances to bring the government back under the control of the Constitution and the people. They'll be then discussing and settling on some course of action. Now, while they're doing this, beginning now, it's already underway across the country. There are 50 state websites now. So there is a state website for California. On that state website is all the official news about the Continental Congress, what it is, why it was convened, what the issues are, debates, chat rooms, all the news coming out of the Continental Congress from their delegates, all this information being populated on the state website. Over time, between now and the time of the Continental Congress and while they're convened, in each state, more and more people are encouraged and gravitate towards that state website. And the prayer is that the dots are connected. We seemed, in our country, everything seems to be couched in political terms rather than constitutional terms. And they've lost track that there's a pattern here. There's a pattern of one violation after the other, and nothing's really being done about it. People are treating these issues as political questions. Look at the campaign, other than Ron Paul. Who spoke about Iraq, the economy, these bailouts? I mean, who spoke about them in constitutional terms? They all spoke, except for Ron Paul, they all spoke about them as though they were political questions where they had some discretion as to how they were going to handle it if you elected them. And this is how my opponent would treat this issue. They're not political questions, they are constitutional questions. And if they are unconstitutional, they are not to be tolerated. Period. We are not to tolerate unconstitutional acts. To our demise, we tolerate them. So, how do we change this? The Continental Congress, debating these issues, connecting these dots. This is the Constitution. These are its violations. This is what's being done about it. This is the reaction of the government. This is what we now need to do. That's what's going to be coming. And populating these state websites. And hopefully, critical mass is then achieved. 5% ought to do it. That's 15 million people. You get 15 or 20 or more million people who who understand the Constitution and its importance and how important it is to defend it. That it just lies there. It doesn't defend itself. The Constitution lies on your desk. Who's going to defend it if we don't? The government isn't going to defend it. Corporate media isn't going to defend it. Corporate America isn't going to defend it. It doesn't get defended unless we defend it. We're the only ones that can preserve it. So, hopefully over time, there's a critical mass of people who understand and who say, yes, we will stand together. We will put a collective foot down against this wrongdoing, this tyranny of today. We will put a collective foot down. This course of action that these delegates are recommending is justified. And so we will stand together and take this course of action. Mark my words, before this process is over, by the end of this year, we will know just how many of us are really interested in preserving these wonderful governing documents that we've been blessed with. Someone's trying to take them away. How many of us really care? We're going to find out. Mark my words, we're going to find out. So at this point, I would ask, if you are individually willing to be called upon from time to time by your state coordinators and regional coordinators, if you're willing to be called upon from time to time to assist in the work that needs to be done between now and the Continental Congress, in reaching out to other people to let them know what's going on, and to help get 3 good delegates from this state to go off to the Continental Congress. If you are willing to be called upon from time to time to assist with that work, stand up. That's excellent. We said earlier that no court has ever declared the meaning of the last 10 words of the First Amendment, the right to petition the government for redress of grievances. So how do we know what it means? As I've been saying, it means that if we have some evidence that government is violating the Constitution, we can call them on it. They're obligated to respond. If they don't respond, we can retain our money until they do, until these grievances are redressed. And if we do that by the numbers, we'll prevail. It's called people power. But who am I? Is this interpretation the correct interpretation? I mean, it seems to me to be common sense. But you shouldn't take my word for it. You should take the words of our founders and of our historical documents. So where do we begin? We begin with the Magna Carta. This is what it says. If we, our Chief Justice, meaning in those days the monarchy always spoke of themselves as we. If we, our Chief Justice, our officials, or any of our servants, offend in any respect against any man, if we violate the rights of man, or transgress any of the articles of the peace or of this security, and the offense, or the grievance, and the offense is made known to 4 of the said 25 barons, they shall come to us. Or in our absence, they were over in France, or in our absence from the kingdom, they shall come to the Chief Justice. Quote, to declare it, the grievance, to declare it and claim immediate redress. If we, or in our absence abroad, the Chief Justice, make no redress within 40 days, reckoning from the day in which the offense was declared to us or to him, the 4 barons shall refer the matter to the rest of the 25 barons who may distrain upon and assail us in every way possible with the support of the whole community. with the support of the whole community of the land. They shall have the legal right. They shall assail us in every way possible by seizing our, quote, castles, lands, possessions, or anything else, saving only our own person and those of the Queen and our children, until they have secured such redress as they have determined upon. And having secured the redress, they may then resume their normal obedience to us. So we, the monarchy, recognize how important it is, how much we recognize our obligation to respond to petitions for redress of grievances. And we have 40 days to do so. And if we don't, then the people have the legal right to take everything we own except our lives. Our lands, our castles, our possessions, everything else we own except our lives, the life of the king, the queen, the children, and the Chief Justice. And then, having secured the redress, the people may, not shall, may then resume their normal obedience to us. Powerful statement. And this right to petition the government for redress of grievances, for the people to hold the government accountable if the government violates their rights. That right then flourished across Great Britain. 400 years later, as an example, the king then, James, had leanings towards Rome, Catholicism. And he issued a proclamation in which he said, the people of Great Britain have the right to worship any way they want to worship. And I want this proclamation read from every pulpit in the land on this particular Sunday. There were 7 bishops who had a problem with that, a grievance. If they read this, if they read that, if they went along with what the king's proclamation and read that proclamation, they would be acknowledging that this right comes from the king, not from God, which they believed. So they had a grievance. They decided to petition the king. They set off to discuss this with him and express their grievance and to petition the king for a remedy to this grievance. The king heard they were coming. He was happy until they got there, and he heard that they were not going to read this proclamation. And he immediately imprisoned them. He put them all in the dungeon. And there was a trial, a jury trial. They got a barrister, a lawyer. Their defense was, we were simply petitioning the government for redress of grievances. You don't have the right to retaliate when we petition the government for redress of grievances. Retaliation is as harmful, as wrong as the initial grievance, as the initial violation of our rights. And so the jury acquitted them on that defense. And then as those people came to our shores, they of course were claiming and exercising this right to petition the government for redress of grievances, their right to hold the government accountable, and that right was claimed and exercised all the time. Akhil Amar, the professor from Yale, wrote a law journal article on this issue, saying that in those days there was more legislation coming out of state legislatures as a result of petitions for redress of grievances than for any other reason. So it was practice, and as those people came to our shores, everything was fine between the people and the government. The relationship was all right until the end of the French and Indian War, and Great Britain started to treat the people differently here. And they petitioned, but now their petitions were being answered only with repeated injury and retaliation. That's when they set off to Philadelphia to talk about this. What we're doing here now is determining just what was in the minds of our founders when they added the First Amendment to the Constitution. And those last 10 words, the right to petition the government for redress of grievances, what did those words mean at the time? What was their intent? They obviously knew about the Magna Carta. They knew what the right to petition the government for redress of grievances and government's obligation to respond, and what the rights of the people were if they didn't. But theirs were being answered only with repeated injury. Government chose not to justify its behavior. They chose not to be held accountable. They were ignoring the people's petitions, or worse. So those people got together in Philadelphia in 1774. They convened in September. A month later, they passed an act unanimously at the Continental Congress. The title of the act was Continental Congress to the Inhabitants of Quebec. It's an 8-page act. You can find it in Journal 1 of the Continental Congress. We have it on our website in its entirety, 8-page act. In that 8-page act, the founders are saying, in this act we are going to talk about the grand rights of the people, the great rights that the people have, simply because they're alive. These rights don't come, they're endowed by the Creator. People have them simply because they're alive. And in talking about the first of what they called the grand rights, the right to government based upon the consent of the people, they said this: if money is wanted by rulers who have in any manner oppressed the people, they may retain it until their grievances are redressed, and thus peaceably procure relief. It is a non-violent solution to the problem of government oppression and arbitrary power. And thus peaceably procure relief without trusting to despised petitions. The founders knew that people had the right to petition the government for redress of grievances, but they also knew that the government doesn't like opposition from any quarter, and they despise these petitions. They knew that. So without trusting to despised petitions, and without disturbing the public tranquility, the people can deal with arbitrary power, can hold the government accountable by retaining their money until their grievances are redressed. The words of the same people that adopted the Declaration of Independence 2 years later. This is the way Jefferson put it a year later in a letter to the Prime Minister of Great Britain, Lord North. He wrote, "The privilege of giving or withholding our money is an important barrier against the undue exertion by the government, the undue exertion of prerogative, which, if left altogether without control, may be exercised to our great oppression. And all history shows how efficacious its intercession for redress of grievances and establishment of rights, and how improvident, how wrong, how dangerous, how nonsensical, how improvident would be the surrender by the people of so powerful a mediator." You have what the scholars call the capstone grievance, the grievance that capped all the others, the grievance that more than any other led to the Declaration of Independence. The capstone grievance, this is it. In every stage of these oppressions, they wrote, in every stage of these oppressions, we have petitioned for redress. In the most humble terms, our repeated petitions have been answered only with repeated injury. A prince or a government, a prince whose character is thus marked by every act which would define a tyrant, is unfit to be the ruler of a free people. And that capstone grievance, more than any other, led to the Declaration of Independence. The grievance that capped all the others. They petitioned over their grievances, and their repeated petitions were answered only with repeated injury. Therefore, this government is unfit to be the ruler of a free people. And that paragraph made it through every draft of the Declaration of Independence, with the exception of one word. The word free was added before people. A powerful clue as to what the framers had in mind in 1791 when they added the First Amendment. They also, it was common knowledge what the rights of the people were and what the obligations of the government were. State constitutions were being adopted. Here's a section from the New Hampshire Constitution. These words were there initially, and they're still there. Government being instituted for the common benefit, protection, and security of the whole community, and not for the private interest or emolument of any one man, family, or class of men, not even bankers. Therefore, whenever the ends of government are perverted, and public liberty manifestly endangered, and all other means of redress are ineffectual, the people may, and of right, ought to reform the old, as by retaining your money. They ought to reform the old or establish a new government. The doctrine of non-resistance against arbitrary power and oppression is absurd. slavish, and destructive of the good and happiness of mankind. When government violates this Constitution, they are acting arbitrarily, especially when we call them on it and they refuse to respond to intelligent, rational, professional petitions for redress of grievances. They're acting arbitrarily. And to sit by and allow that to happen without resisting, this doctrine of non-resistance, is absurd, slavish, and destructive of the good and happiness of mankind. There's nothing in the Constitution that authorizes the federal government to give or lend public money or credit to any private entity for a decidedly private purpose. Where do they get that authority? So we have a government that violates any of these provisions. They just finished writing the rule book. They just finished putting it together. And they stepped back, and the state said, wait a minute, suppose the government violates any of these rights. Any right that is not enforceable is not a right. That's well settled in American jurisprudence. Any right that is not enforceable is not a right. And so they put the accountability clause right there as the capstone right there in the First Amendment. They violate any provision of the Constitution, we have the right to petition them for redress of that grievance or remedy. If they don't respond, then we have the right to withdraw our resources and our support from that government, because that's not the government we set up. The right to free speech, press, and assembly, as we're doing here today, are derivative rights. They derived from the pre-existing right to petition the government for redress of grievances. They derived from the right. They were necessary to protect the pre-existing right to petition. Before this right to petition was fully recognized, as with the Magna Carta, if anybody in Parliament spoke up and said anything unkind about the king or the queen, then the king had and he often did, he just dissolved Parliament. Just dissolved them. Maybe started up another one. Or worse, maybe he took somebody's head. And people in the press couldn't write about, couldn't say nasty things about the monarchy, or they would be prosecuted. But in 1995, we began to focus some efforts at the federal level. In 1995, President Clinton and his Treasury Secretary, Robert Rubin, from Goldman Sachs, everybody seems to come from Goldman Sachs, they bailed out, on their own, without going to Congress, they decided to bail out the Mexican peso to the tune of $20 billion. We did the research. We had the wonderful assistance of a former director of research at the New York Federal Reserve, and we prepared a brief, went to court, to prevent any of that money from flowing down to Mexico until this underlying constitutional question was settled. We argued there's no authority in the Constitution to do this, and we need to settle this issue now. There may be future bailouts. And so we thought we did a pretty good job. We filed a brief. Janet Reno was the Attorney General. She asked the court to dismiss the case on the basis of sovereign immunity, saying this government was sovereign, we're not, we don't have any right to sue the government. We had the assistance of Akhil Amar and others, and did a good job and forced her to withdraw that defense. We're sovereign. The government is not sovereign. We are the final arbiters of the Constitution, not the government. But then we knew that the government frequently will dismiss cases on the basis of lack of standing, saying our harm is no different from the harm of anybody else in our country. And so therefore we have no standing. So we thought in preparing the case, we've got to get some people as plaintiffs who clearly have standing to make it hard for the court to abuse the standing doctrine. In 1999, I was getting ready for the show one day, and I saw an email. The email had to do with a fella not too far from here, from San Jose. His name is Joseph Bannister, a devout Christian who comes from a family of uniformed officers, fathers, brothers, state police, local police, firemen, outstanding individual. Became a CPA for Pete Marwick and Mitchell for 4 or 5 or 6 years. Decided he wanted to go to work for the FBI or the Treasury Department. The FBI had a hiring freeze on. He was hired by the Treasury Department, went to work for the IRS as a special agent in the Criminal Investigation Division. He was trained to enforce the Internal Revenue laws. The Internal Revenue laws are fine the way they're written, but they can be enforced in a way that's unconstitutional. So the laws might be constitutional on their face, but according to Joe Bannister, they appeared to be unconstitutional in the way they were being applied. He had written on his own time, he was out, special agents have badges, guns, they have cars with all of these bells and whistles. And he was out in the San Francisco Bay Area one day. He was listening to a talk show host by the name of Jeff Metcalf. And Jeff Metcalf was talking to a woman named D.B. Kidd. And they were talking about the fact that the way that the government, the IRS, is enforcing the Internal Revenue laws, it violates the tax clauses of the Constitution. And Joe Bannister, devout Christian with clearly a conscience, said, my gosh, they're talking about me. And he said, they can't be, that can't be. I am going to look into this. And on his own time, over 2 years, he did his independent research. And at the end of, and he set out to prove them wrong. But along the way, he got turned around. And he, in February of 1999, he issued his superiors at the San Jose office a 95-page report. And within a week, they fired him. He led his class and all of his training, brilliant man, and they fired him. And so I had the producer track him down, spoke to him on the air, and he introduced me in the audience to a couple of other people, Bill Benson, the constitutional attorney, Larry Beecraft, and so forth. We had them all on the air. And we asked the audience, okay, we've got some evidence that the government is violating another provision of the Constitution. What does a free people do about this? What is the appropriate next step? So we wrote a letter to the leaders of the 2 political branches, the Congress and the executive branch. We invited them to send their best and brightest to meet with our people, Joe Bannister and these other folks who have been petitioning without success, to meet with them at the National Press Club in July of 1999. We were there. The government didn't show, but C-SPAN showed and broadcast the event for 3.5 hours live. And there was Joe Bannister on national television telling his story. There was Bill Benson on national television telling his story. There was the constitutional attorney, Larry Beecraft, telling his story. In November of 1999, it was decided if they won't come to us, we will prepare petitions for redress of grievances and we will bring it directly to them. How do you go about serving a petition for redress of grievances? So I went down a week before the event to find out. I went to the White House. I had never been there before. There was a fence around the compound that has the White House and the Treasury, the main Treasury building are in the compound. And there's a gate around the compound. I went to, and they have these security shacks every so often. And I went to one. And as I approached, the voice inside says, "Can I help you?" And I said, "Well, I'm Bob Schulz, chairman of the We the People Foundation for Constitutional Education. Next Tuesday, there's going to be a delegation of people representing all 50 states gathering at the National Press Club. And at 1 o'clock, we're all going to come over here to serve a petition for redress of grievances on the president regarding the legality of the income tax. Who's going to receive us? What gate shall we come to?" The guy came out and he says, "You know, I've been here a long time. This has never happened." He said, use this phone. Call this number. I did. It was at some department in the White House. I said, I'm Bob Schulz. I'm chairman of the We the People Foundation for Constitutional Education. Next Tuesday, there's going to be a delegation of people representing all 50 states gathering at the National Press Club. And at 1 o'clock, we're going to be coming over here serving a petition for redress of grievances regarding the legality of the income tax on the president. Who's going to receive this delegation? What gate shall we arrive at? The person said, I don't know. Let's try this department. They switched me over to another department. I was there for 2 solid hours talking, but after 2 hours, everybody in the White House knew that next Tuesday there was going to be a delegation of people representing all 50 states gathering at the National Press Club to serve this petition for redress of grievances on the president. Finally, someone said, you know, we don't know how the people go about petitioning their government for redress of the grievances, claiming and exercising their First Amendment right. So why don't you go home, call us tomorrow, we'll have an answer for you. I went home, called them, there was no answer. We had the conference, they didn't show. We then decided that we would run full-page ads in USA Today. We contracted with USA Today to run 12 at the cost of $67,000 each. What does a free people do when you have government who has stepped outside the boundaries? Do you just say, well, let George worry about it. I'm going to take care of my family and my career. It's up to George, whoever George is. No. So we ran 4 of those 12 full-page ads when a young lady named Katie Emery called. She was our account executive. And she said, Bob, we can't run any more of the ads. Well, why not? She said, the tax people have been in talking to our legal people. And I said, by the tax people, do you mean the IRS? And she said, yes. And I said, are you telling me that your legal people have bought whatever it is that they were told? That maybe I should come down and talk to your legal people. Maybe they will answer the questions that the government refuses to answer. Maybe I should come down and talk to your legal department. And she was young and naive, and she said, great idea, I'll set it. So I went down, and they would not see me. Shortly after, that same week, on a Friday night, I received a phone call at 7:30 at my home from David K. Johnston, K, C-A-Y, David K. Johnston. He was the tax reporter for the New York Times for 30 years. And he said, Bob, do you know that the Senate Finance Committee is holding a hearing on your ads? They're going to be blown up, and they're going to be on easels? And I said, no, I didn't know that. And he said, what are you going to do about it? Good reporter, right? Fanning the flames. So I said, I don't know, what do you do? And he said, well, I would call the committee and ask to be a witness at the hearing on your ads. And I said, that's a reasonable request. So I called the Senate Finance Committee. It was chaired by Senator Grassley. And I spoke to them and told them who I was, and we were in the ads. We understand they're going to be blown up on easels, you know, and they're going to be talked about at this hearing. Could we be there as witnesses? We'd like to testify. She said, put your request in writing and fax it down, which I did that afternoon. I got a response signed by Senator Grassley saying that the witness list is closed. So we called Joe Bannister and Bill Benson and so forth, and we said, I think we should all go down there anyway and try to speak at this public hearing. We'll get there early, we'll get a seat, we'll request to be speakers, witnesses. And we were there, we were not allowed to speak, but we did submit a comprehensive statement for the record. But at that hearing, there was a young lady who was a witness, and she pointed to our ads, which were blown up and which were on easels. And she said to the chairman of the committee and the other members on the bench, she said, these people are merely asking you to answer their questions. Maybe you should answer their questions. Maybe you should respond to the petition. It's as though she wasn't in the room. The chairman talked right over her head, wasn't going to go there. It's like he didn't hear what she just said. They were not going to set that precedent of responding to the people's petition for redress of grievances. So now the question is, what does the free people do now? What's the appropriate next step? We decided to take a page out of the Bible.
Put him in jail, that's what we
No, no, you have to exhaust your remedies.
Then put him in jail.
Coming to that. We're still exhausting our remedies here. All right. You know, the people are petitioning their government, writing letters to their congressmen, writing letters to the IRS. They're not getting any answers. And so they're acting on their beliefs. And the government is cracking down on these people, turning their lives upside down, garnishing their weight. They don't answer, you know, except with a heavy stick, a heavy hand. People are committing suicide. This is a pretty serious matter here. What's the free people do about this? When you have some evidence that the government is violating the Constitution and you're trying to hold them accountable, and they refuse. I decided to write a letter to the President, another one, and to the Speaker and to the Senate Majority Leader. And in very respectful tones, I summarized all of these attempts to get the two sides together, and I said, I'm going to go on a hunger fast. I'll be coming down to Washington on July 1st, and I will not eat again until you at least let us know when these petitions and then when these questions are going to, when you will respond to this petition for redress of grievances. And so on the 19th day, a fellow named Lawrence Lindsay, you hear about him quite often these days, he wrote a note on White House stationery. He was head of the Council of Economic Advisors. He wrote a note and delivered it. He said, you will be receiving a substantive response from the government. And it would be nice if you would end your hunger fast. The next morning, the IRS commissioner called and said, okay, we agree to meet in a recorded public forum and answer the questions, respond to the petition. That afternoon, Ashcroft, the Attorney General, called and said, okay, we agree to meet and we'll respond to them. We'll address these issues. I was in the office of Roscoe Bartlett, Congress, a wonderful man from Maryland. And Dan Bryant, the number 3 man from the Department of Justice under Attorney General Ashcroft, he called and he said this to Congressman Bartlett. And I wasn't sharp enough, after 20 days, I wasn't sharp enough to pick up the significance of this. But what he said to Congressman Bartlett was this: we do not want history to show that we, the government, are responding to a citizen's petition for redress of grievances. We want the record to show that we are merely responding to a congressman's letter, so write a letter. And we sat down and Roscoe Bartlett hand wrote, we worked out the language, and he wrote the letter, and he said, let's go deliver this. So we went over and met in Ashcroft's office with Dan Bryant. And we said, and he confirmed that they would agree to meet in a recorded public forum. We said that we had so many questions, we couldn't do it in one day, we needed 2 days. They said, that's fine, but this will have to be done in a secure location. We don't want people coming in off the street disrupting things. And so Congressman Bartlett said, well, there's no more secure location than, say, these hearing rooms on the Capitol Hill are very secure. So that was agreed. We said we only wanted 1 camera crew. And the government could have 1 camera crew. We didn't want a lot of cameras, distracting things. And that was agreed. And 2 dates were set, September 23rd and 24th, 2001. This was now July 20th, that we were over there negotiating. We set 2 days, September 23rd and 24th. On September 11th, we had, September 12th, we contacted the government and we said, look, under the circumstances, we should postpone this to 2 days in February, and that was agreed. And eventually they pulled out. They just decided they weren't going to do this. I mean, they were feeling quite strong, could do no wrong, the country's under attack, this strong feeling of nationalism, who's going to be paying attention to this, and so forth. But I think the real reason they canceled was this. We decided that we would, once they agreed, I and our IT person went down to inspect the hearing room. It was the science hearing room in the Rayburn House office building. to check out its wiring and to see what we needed to do to have a live webcast of this two-day event, with the government responding to our petition for redress of grievances regarding the legality of the income tax, a violation of the taxing clauses of the Constitution. And what we did shortly after that was put on our website that we were going to have a live webcast of this event, and it would be to pay for it, we would set it up on a pay-per-view basis. So for anybody for $19.95 could watch any part of the two-day hearing, and then get a DVD of the whole hearing at the end. And thousands of people were signing up, and the government, of course, is watching this. And I think that's why they pulled out. Those cameras were going to be right on their faces as they answered these questions. So they haven't responded to the petition for redress of grievances regarding the violation of the tax clauses. Let's talk briefly about the petition for redress of grievances regarding the Iraq resolution. You need to know these things. You need to know the facts of what people have been through to hold the government accountable to the Constitution, and what government and how government has responded. It's pretty well understood now that President Bush wanted to go into Iraq from day one of his administration. Now it's 2002. In the fall of 2002, the war drums are really beating. The White House prepared what is known as the Iraq resolution and sent it over to Congress. If Congress passed it, it would have Congress saying to the president, it's your decision if we're going in and when. It's your decision. Well, there isn't anything in the Constitution that authorizes one branch to transfer the power. We have given it to another branch. But that's what this was. And so the Iraq resolution fell to the House International Relations Committee, chaired by Henry Hyde, who I had a lot of respect for until this happened. Henry Hyde scheduled a debate on the White House Iraq resolution on October 2nd and 3rd, about 5 months before we went into Iraq. Ron Paul was on that committee. Ron Paul's turn came to speak on October 3rd, the second day of the hearing. Ron Paul stood up and he said, I have a substitute amendment for your consideration. As soon as he said that, they had to vote on his substitute before they voted on the White House's Iraq resolution. And what did Ron Paul say? He said, if you vote for this, you're declaring war. This is what you should be debating, whether you're going to declare war or not. And he did a very good job of defending the Constitution, quoting the Federalist Papers in Madison and so forth. And when he was finished, Henry Hyde, the chairman of the committee, said this, quote, events have overtaken the Constitution. Ron Paul's substitute amendment, of course he voted against it, his own amendment. He didn't believe we should be invading Iraq. And when they did that, then they passed the president's Iraq resolution. When Henry Hyde said that, what clearer indication, what clearer evidence do we need that the Constitution doesn't really mean anything to these people anymore? You know, it's inappropriate and anachronistic. But that's not how you change the Constitution, by ignoring it. We've been petitioning. When we heard that, we decided to prepare a formal petition for redress of the grievance regarding the Iraq resolution, and to serve it on every member of Congress and the President. We prepared it. We decided while we were doing it, we'll do 3 more. And we'll serve every member of Congress and the President with a total of 4 petitions for redress of grievances. Not just this one, but one on the constitutionality of the Federal Reserve, one on the USA Patriot Act and its violation of the privacy clauses. The Federal Reserve Act, the Federal Reserve is a violation of the money clauses, and then another one on the direct unapportioned tax on labor. So we'll have 4. We'll serve all 4 on every member of Congress. We served them on every member of Congress on November 8th. And at that time, we asked each member of Congress to please send a representative over across the street to the National Mall, where there'll be be a gathering of people from all over the country who will caravan there. Please send a representative over and at least let us know when you will be responding to these petitions for redress of grievances. And we were there on November 14th. I flew to San Francisco. We drove across with a caravan of cars. Cars came up from Texas in different directions. So there we were on November 14th. We had a stage. We had staged, we contracted with this company that stages all the main events on the National Mall, including the fireworks. So we had this stage. We had constitutional scholars giving speeches. We had music. We had big banners. It was an all-day event. We did a live webcast of the event all day. And we said at a very dramatic moment in time, we asked the crowd to part. Please part. Make room for these representatives who will be coming from across the street to respond, to at least let us know when they were going to respond to our petition, 4 petitions for redress of grievances. In a very dramatic moment, the crowd parted and no one showed. It's all part of the record. We've been establishing a rock-solid record, just as the founders laid out their petition for redress and had a record to stand on. And they settled on a course of action based upon their record. And people sympathized with them and agreed with them that course of action was justified in the face of those facts and circumstances. We've been doing the same thing for years. We petitioned for redress of grievances regarding many other issues. The federal gun control laws and their unconstitutionality, the absence of any authority to develop a North American Union. Last September, I was reading the New York Times, and I read that Mr. Paulson and Mr. Bernanke had entered into an agreement with AIG, and we're going to give them $85 billion. So I looked at the Constitution, and all I could find was the Commerce Clause, which authorizes the government to regulate business, not to participate in it. You know, we were going to own AIG. I couldn't find anything in the Constitution that authorizes the government to give or lend public money or credit to any private entity for a decidedly private purpose. And so we didn't want any of this money to be transferred until this underlying question was settled. So that with the assistance of constitutional scholars, we prepared a complaint. And we rushed it down to Albany, where the federal court is, and we filed the lawsuit, saying there's no authority here. Not only is this outside the boundaries that we've drawn around their power, it's unconstitutional, but they didn't even go to Congress this time. Then I got on the phone with the lawyers at the Treasury Department, explained to them the nature of the suit, and that there was a restraining order. And my wife, Judy, faxed them, as she had done with the lawyers at the Federal Reserve, a full set of the papers, 35 pages. And then under the rules, you also have to notify their lawyer. So I got on the phone with the lawyers at the Attorney General's office and notified them of the suit. I mean, what's a free person to do when you have evidence that the government is stepping outside the boundaries? Talk about it as though it is a political question? No, it's a constitutional question, and therefore it's intolerable. And so we, by 3 o'clock, I had notified all of them, all the defendants, and you may recall that it was that night that there was a hurry-up meeting between Mr. Paulson, Mr. Bernanke, and the leaders of the House and the Senate. And they came behind closed doors, and these politicians came out from behind those closed doors, and they had these very long faces on. And they said, oh my gosh, Mr. Paulson, Mr. Bernanke, they just explained to us that the sky is falling, that the bottom is about to fall out of the economy, that credit's going to dry up. Oh my gosh, we're in for a lot of trouble, and they promised to come back to us in a couple of days with legislation so that we in Congress can prevent this from happening. And it was that Saturday, that following Saturday, that you may recall, they did come back with a piece of legislation for Congress to sign. It was a 3-page bill. It said, if Congress passed it, it would say, it would have the Fed and the Treasury giving them the right to print or borrow $700 billion, give it to these private companies, buy these mistakes. And nobody can challenge it in any administrative agency, and nobody can challenge it in court, period. Please pass this bill. And eventually the bill turned out to be a 450-page bill. And there was another constitutional question along the way. The bill that was eventually signed originated in the Senate, but all money bills are supposed to originate in the House. Remember, the House turned it down, then the Senate passed and then sent that over to the House, and they passed that. That's not the way the Constitution is designed to work. Anyway, now we had a 3-page bill, and we said, well, we don't have the authority to do this either. So we drew up another complaint and drove it down to Albany, and the court consolidated the two cases. And of course, at the same time, they got together with the Justice Department, they stepped on the hose, they put their foot out, and they slowed things down so that all the money was transferred before the court acted. Finally, the court acted. The government asked the court to dismiss the case, and the court did. About a week or so before I started this tour, the second tour, they dismissed the case for lack of standing. Once again, this is how politicized and just how corrupt the judiciary is. They're cooperating with the other two branches in a collective decision over and over again to deny us our constitutional rights. But at least we are exhausting our administrative remedies, we're exhausting our judicial remedies, and we are now exhausting our constitutional remedies. And the case has gone on appeal, I should say. We always take everything we do all the way. We take it to the Supreme Court. We never want the other side to be in a position of ever saying, gee, if we had only appealed, things might have gotten turned around, you may have won. No, we take it all the way. So we've been petitioning for a redress of many grievances, and you can read all about them on our website. But this is our capstone grievance. Just as the founders had a capstone grievance at the end of their list of grievances, they said, have we a petition for redress of these grievances in the most humble terms, and I'll repeat a petition to be answered only with repeated injury? A prince whose character is thus marked by every act which defied a tyrant is unfit to be the ruler of a free people, therefore we're out of here. That was their capstone grievance. This is our capstone grievance. In 2004, 1,450 people from across this country, brave, courageous individuals, became plaintiffs in an action for declaratory relief, it's called. We simply went to the federal court to have the court declare what our rights are under the First Amendment Accountability Clause, the last 10 words, something the courts have never done. And we said to the courts, we'd like you to answer 2 questions. First, is government obligated to respond to these petitions, to respond to the people's attempt to hold them accountable? Are they obligated to respond? And if they don't, do the people not then have the right to retain their money and their resources until their grievances are redressed? 2 simple questions. The federal courts did this. There's another judicial doctrine, it's called stare decisis. 2 words, S-T-A-R-E-D-E-C-I-S-I-S, stare decisis. It means this. It's a good doctrine, just like the standing doctrine is good, but it can be abused. The doctrine they apply to our case, the doctrine of stare decisis is this. If the Supreme Court lays down a principle of law in a case, and then you come along later in time, a week, a month, 100 years later, and you bring a case, and the facts of your case are similar to the facts of that earlier case, and the law that you're arguing, that you're standing on, the right or the law that you say has been violated, is the same as the law that was argued in the earlier case, then the principle of law laid down in the earlier case applies to you. It's called case law. It's called precedent. It's a good doctrine. But here's what the federal courts did in our case. This is our capstone grievance. The federal court said, oh, gosh, the government does not have to listen or respond to your petitions because the Supreme Court said so in a case that it decided in 1979 and another one in 1984. And if the government doesn't have to listen or respond to your petitions, then you don't have the right to retain your money until they do. Case closed. Well, what were these 2 cases? We thought we really did our homework on this. The first case came out of Arkansas. The second case came out of Minnesota. The first case that was decided by the Supreme Court in 1979, out of Arkansas, what were the facts? These were the facts. The state legislature passed a law that said public employees of this state, if you have an on-the-job related employment-related grievance, you must submit them as individual employees to your public employer. You cannot form an association and have the association submit your grievances. You must submit them directly. Well, you had state highway workers in Arkansas who formed an association and had their association submit their on-the-job related employment-related grievances. And the state of Arkansas said, we don't have to listen or respond to you. Submit your grievances directly and we'll respond. That case went all the way to the Supreme Court. And the Supreme Court said, in this context, the government does not have to listen or respond or even recognize this association. What happened in Minnesota? There, the state legislature passed a law that said, public employees of this state, if you have on-the-job related employment-related grievances, you must submit them through your association or your collective bargain, your union. You can't submit them directly. Quite the opposite, the converse of what was happening in Arkansas. Are the facts of our case anywhere similar to the facts of the other case? We're not public employees. These are not on-the-job related employment-related grievances. These are violations. Our grievances deal with violations of the Constitution of the United States of America by our elected officials. And is the law we were arguing similar to the law, or was it the same law, rather, that was the same law that was argued in the earlier cases? We're arguing the original intent behind these 10 words. We're saying to the court, based on the Magna Carta on forward, we documented everything. We said, based on the historical record, the context and purpose of these 10 words, what these words meant when they were written, the original intent of these framers, it means if we have some grievance, some violation of the Constitution, we can petition the government. They are obligated to respond, and if they don't, we can retain our money. And there is nothing in American history of jurisprudence, we argued, that contradicts that interpretation. So, defendants, we sued the government. Tell us we're wrong. We're not entitled to our version of the facts. Offer your own. Refute these facts. That case, the argument we were arguing, Judge Judith Rogers, one of the 3 judges on the United States Court of Appeals for the D.C. Circuit, in deciding this case, which was called We the People versus the United States. There were 1,450 plaintiffs in this case. Individual named plaintiffs. This was not a class action. If you've ever seen a lawsuit, the caption of the case is that part, is what they call that part of the front page that deals with these people are suing these people. Normally the caption takes a third of a page or a half a page. The caption of our case took 56 pages. These were the people, their names and their addresses, going to court, asking the court to declare their rights and the government's obligation under these last 10 words. That's how important this is. And so Judge Rogers wrote a separate 9-page opinion when they decided our case. What did Judge Rogers say? She said, hold everything. I read the legal briefs in the Arkansas case and the Minnesota case. This argument before the court right now, based upon the original intent, what she called the historical context and purpose of those 10 words, that argument was not argued in those cases. I read the brief she wrote. And she went on to say, it's going to be interesting to see how the Supreme Court handles this case. Wow, I said, she would not have written that. I mean, she went that far? She would not have written that if she and her law clerks had not talked to the judges and the law clerks at the Supreme Court just a few blocks down the street. Wow, the Supreme Court's going to hear the case. Wow, isn't it going to be wonderful? The Supreme Court's going to have to come to the same conclusion we've come to on the meaning of the last 10 words of the First Amendment. We have some evidence the government's violating the Constitution. We can call them out. They're obligated to respond. If they don't, we can retain our money until they do. Wow. There's going to be this tremendous shift of power from the government back to the people where it was meant to be in the first place. We're going to be able to hold them accountable to the Constitution. Wow. Can't wait to get my application into the Supreme Court. They're going to hear the case. So we got our application in, and in one word, the Supreme Court said denied. They don't even give a reason. Just denied. They don't want to hear the case. For whatever reason, political or otherwise. What is the job of the Supreme Court? If it isn't to apply the Constitution, to hold the other 2 branches in their constitutional places, regardless of the level of practical difficulty. What is their job? This is a first impression case. I mean, this is a first impression case that they've never declared the meaning of these words. It's all part of the record. It is a solid record, just as the founders had a solid record that they could stand on when they took the course of action that they took. And they gave us the ability, 2 accountability clauses right in the document itself, in the First Amendment and in the Second Amendment. We can solve this problem peacefully, but it's going to take a critical mass of people. Don't wait, and don't think you can, as an individual or even a small group, prevail against the government of today. You can't. And don't wait for an individual or a small group. We have an opportunity to prevent the violence that is surely coming if we continue on the course that we're continuing on. The people running this country now, they are believing and acting as though we are a democracy, where if you don't like what's going on, just vote for somebody else, that this doesn't matter anymore. And so we can avoid that violence if we achieve critical mass, if we achieve a mass movement. It's called people power. It has always worked. The Continental Congress is the appropriate next step. Let's get there. Let's get good delegates from each state. Let them discuss these provisions of the Constitution. Let them discuss these violations and people's attempt to hold them accountable. Let them discuss government's reaction or their lack of accountability. And then let them debate the appropriate course of action. This is not a We the People organization function. All we're doing is facilitating it. If we're going to be successful or not is up to you. The people of each state can only make this happen. Remember I said there are 2 separate entities within the We the People organization. There's the research and education arm, that's the foundation, and then there's the civic action arm, that's the Congress. Here's the website for the We the People Congress. You'll notice there that there's this link to a trifold. So it's wethepeoplecongress.org, and here's a link for a trifold brochure. Print it out, get copies made, pass them out wherever you can. It's all about the Continental Congress, just about the Continental Congress. Here's a link to find out what the procedure is for nominating delegates to the Continental Congress. Click on there, read about it. Here's a link for you to actually nominate people that you think should be the delegates representing your state, the people in your state. There are hundreds of nominees already that have been submitted in this database. What we're doing is contracting with someone for $30 a head to tell us that these people are the people who they say they are. They are who they say they are. That's all we're doing. We then turn it over to the state and regional coordinators in your state. And for you then to finish the vetting process. So you need to form a nominating committee and take a hard look at these people who want to be delegates to this Continental Congress and vet them. And once you're satisfied with them, they then get posted on the California State website. I don't know how many nominees you'll have eventually, but they'll all be listed on the California State website. Then there will be a vote by affidavit. Paper ballots, hand-marked, hand-counted, will be used to choose from that list of nominees who you'd like to be your delegate at the Continental Congress.
That's what you do. I mean, you're going to meet and then what's the next step?
Okay, good question. All right, the question, and you should all hear this. The question and the answer. The question is, I think, if I could rephrase it, what might they recommend? What might come out of the Continental Congress? What might be the next step? Right? So it's difficult to know. All the way for 30 years, we're always asked that question, what if? And I say, I don't know. You do the right thing of what you're doing at the moment, and everything else will take care of itself. But you always take the appropriate next step. So it's a difficult question to answer. But let me try. There's a lot of what ifs and a lot of scenarios. Here's one that could unfold. Let's say that the delegates to the Continental Congress decide that under the facts and circumstances, it's necessary for the people to begin to withdraw their support and their resources from the government until these grievances are redressed, or in some cases reversed. And let's say that, my gosh, there's 15, 20 million or more people across the 50 states who now believe that it is time to do this, that such a course of action is justifiable, and they're willing to participate in putting a collective foot down to stand together to bring to bring the government back under the control of the Constitution. So the question is now going to become, what is the government going to do? What is the government then going to do if the people, in this peaceful, nonviolent way, decide to withdraw their money and their resources from their time, their money, until these grievances are redressed? Is the government going to stand down, or are they going to clamp down? If they clamp down, then the ball then goes it's again in the people's court. What would be the appropriate next step for the free people of this country to take if the government clamps down on them as they withdraw their support and resources from the government because the government has refused to be held accountable, has refused to respond to all of these petitions, and they're clearly outside the boundaries that we've drawn around their power? What will the people then do? It will bring tears to my eyes. It would be so painful to see violence erupt in this country, not in the form of a standing army, people standing up against the government, but the kind of violence that you have in so many third world and southern and Latin American countries, where the people are oppressed, and the oppression is so great, and these people just target individual judges or tax collectors or whatever, and they take them out, or they try to take them out. That kind of violence goes on all the time. It would be heartbreaking. Years ago, there was, remember this magazine, maybe it's still out there, this magazine section that was inserted in your Sunday newspaper called Parade? Remember that? There was a photograph, it's still there? There was a photograph that I'll never forget. It was the bridge over Selma, the bridge into Selma. Martin Luther King, and they were told they couldn't march. And they did anyway. And there they were, long line of them. And there they were in their Sunday best, not offending anybody, arm in arm. And they walked over the bridge, and of course they were attacked by the government. They were attacked by the dogs and the hoses and so forth. And what happened? That made television. People around the rest of the country and the world, their sympathies went to the people, not to the government. And that was the beginning of the end. That turned the situation around, for those people who were defending their civil rights, their constitutional rights. But civic education without action at this point is for naught, I think. Anyone else? Yes?
Given the fact that timing is everything, given the fact that generally people don't respond until the wolf is at their door, given the fact that a lot of people have lost what they thought they had as well, given the fact that trillions of dollars are being spent out of nothing, created out of nothing, and given the fact that our benefactor, China, is starting to rebel against their responsibility of buying our debt, what do you think is the appropriate timing to have the critical mass of the general public to have an effect on our government?
That's difficult. I mean, who really knows? It's difficult. You don't want to wait until you need a wheelbarrow to get a loaf of bread. At that point, there's real serious trouble. The government who created this trouble is now offering a solution that's going to create more trouble. It's the way it works, if you read Atlas Shrugged. So I don't think we should wait until that point, because then so many more people are going to be dependent upon the government. And they think the government is going to save them. I think the timing is perfect right now. By the way, I've been saying this to every group I've been meeting with lately. Wouldn't it be nice if Ron Paul were to resign his seat at the Congress and preside over the Continental Congress? Wouldn't that be a nice So write him a letter.
So will you call him and ask him?
Well, I tell you, I did talk about this this upcoming train ride. One of the people I did call was Rand Paul. He and I were speakers at the Boston Tea Party event in December, and so I called him and I told him about, he knew about the Continental Congress because that's where I laid it out initially. But I asked him, I told him about the train ride, and I said, do you think you and your father might like to take the train down to Jekyll Island? And he said, I don't think my father would want to take a government train, meaning Amtrak. But he said he might meet you there. I'll talk to him, send an invitation. We the people need to get our act together and to set up an organization whose purpose is to scrutinize, to help other people become better informed about their rights, what their rights are, better informed about what's really going on in government, and better informed about how to professionally, intelligently, rationally, nonviolently confront government wrongdoing wherever they see it. We need an organization. We need to institutionalize that kind of vigilance, and I'm committed to making that happen.
I just want to thank Bob Schulz and Judy for going the distance all over the country. We're so grateful. You have no idea. We're so grateful.
Well, there you have it. Wise words indeed. I would like to thank Bob Schulz and his terrific wife Judy for all the hard work and devotion they have given to help us overcome the issues of the day. And I would like to thank Bob personally for having the courage and the strength of character to provide extraordinary leadership in a time when it is truly needed most. For more information on We the People Foundation and how you can help, stay tuned for the website address coming right up. Thank you for joining me, and I look forward to seeing you again on our next segment of What the Heck is Going On? I'm Jeff LaFrance, wishing you all the best that life has to offer. Thank you.